Now, could each witness please, starting from my left, state their name and position, title, and swear either an oath or an affirmation? Starting with yourself, Dr. Boersma.
So my name is Martijn Boersma. I'm an associate professor at the University of Sydney. And I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Dr. Boersma. Dr. Wright.
Thank you, Chair. My name is Chris Wright. I'm also an associate professor at the University of Sydney. And I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thanks, Dr. Wright. Would you like either of you make a brief opening statement of a couple of minutes for each, perhaps with yourself, Dr. Boersma?
Sure, and I'll be making a statement on both our behalves.
Okay.
Yep. So we're very grateful today to speak about the Ethical Clothing Extended Responsibility Scheme of 2005. This scheme, which is currently underutilized, stands, in our opinion, as a vital tool in the enforcement of labour standards within New South Wales textile clothing and footwear industry, also TCF industry. The workforce in the TCF sector, as outlined in our submission, is particularly vulnerable to labour standards non-compliance and exploitation. The industry predominantly employs workers who are culturally and linguistically diverse, with many facing significant barriers such as limited English proficiency and precarious employment conditions. This demographic profile inherently places these workers at higher risk of modern slavery-like practices. The scheme is an important example of regulatory innovation that plays a vital role in ensuring business compliance with employment regulations and ensures TCF workers receive the wages and conditions that they are legally entitled to. Current modern slavery legislation, such as the Modern Slavery Act 2018, relies heavily on transparency measures. However, there's growing recognition of the need to shift towards due diligence and more proactive enforcement to effectively mitigate the risks of modern slavery. The Ethical Clothing Extended Responsibility Scheme provides an avenue to facilitate this by ensuring greater accountability and transparency throughout the supply chain. By leveraging the scheme, we can enhance oversight and enforcement, ensuring that even smaller entities and subcontractors are held to high labor standards. This approach complements existing legislation and addresses the gaps where risk of abuse is most acute. In conclusion, strengthening the application of the scheme is imperative to protect vulnerable workers and uphold ethical standards in the TCF industry. We urge the committee to consider the recommendations for promoting supply chain mapping, creating a comprehensive supply chain database, and exploring the extension of the scheme to other high-risk industries. Thank you.
Thanks, Dr. Boersma. I might just start with a fairly general question. And obviously this is the Modern Slavery Committee, so we are interested in the application perhaps to instances of modern slavery. You've indicated the possible applicability of this scheme more broadly. I wonder if you could just expand on that a bit and how the Anti-Slavery Commissioner might participate in that.
Sure, I'm very happy to. So in effect, the current modern slavery legislation relies on transparency, but this transparency is not necessarily very strategic. So what happens is that entities that are required to, and some do so voluntarily, report on the risks in their supply chains with regards to modern slavery and the measures they are taking to, I suppose, address those risks. But it's a bit unclear who exactly the conferring public is. So who is it exactly that's reading these statements and acting on these statements? Now, what legislation tells us, and the guidelines accompanying legislation tells us, is that businesses themselves, as well as consumers, as well as investors, are taking note and I suppose are adjusting their behavior accordingly, choosing to do business with the ones that produce better modern slavery statements and avoiding those that don't. Now, from the evidence that we've seen federally, but also in the UK, there's limited, I suppose, empirical data that supports that those stakeholders or those conferring publics are acting on that basis. Now, this brings us to the scheme. What the scheme does is, I suppose, look at this type of transparency in a much more strategic way, and effectively what it does is provide transparency on very select data, data points which are very helpful in assessing whether exploitation is taking place and whether legal entitlements are being paid. But also it provides that data to a very select group of stakeholders. So by providing that to, in this case, the union, but also possibly New South Wales Industrial Relations, but also, as you mentioned, the Office of the New South Wales Anti-Slavery Commissioner, we have obviously conferring publics that are not abstract investors or abstract people in the market who may or may not change their behavior on the basis of these disclosures. We have obviously a regulator, a union, and I suppose in those capacities, and an anti-slavery commissioner who have a very direct interest and the capacity to act on that information and to leverage that information in order to, I suppose, get better outcomes for workers. And in that sense, the scheme itself is very complementary to the work that the Office of James Cocaine is doing, but also what New South Wales Industrial Relations could be doing.
So, in essence, the current framework around modern slavery is we've got these statements that are made, and no one reads them. I mean, not no one reads them, but they're not the sort of thing the general public goes to and makes decisions around products on. And you're saying that an alternative approach, I'm just trying to encapsulate this, an alternative approach is to collect the data, but actually make it more specific and to specific interested parties.
Yeah.
Okay,
Yeah.
Thank you. I might now go to Ms. Kane, Dr. Kane, for the
you.
next question.
I know that both of you, I know your work quite well, and I know that both of you would have been listening with interest to the previous witnesses. And I guess the first thing I wanted to do is get a response to that evidence, particularly I think with the chair reminding us again that we've got a modern slavery focus. So I guess maybe starting with you, Dr. Wright, the supply chain work that you've done, how is that structure and those characteristics of supply chains, how is that relevant to us thinking about modern slavery, and what are the kind of leverage points available if we're trying to look at ways that mitigate it?
Thanks, Dr. Kane. So, at the risk of being a bit too academic, I would just like to return the committee's attention to evidence provided by Mr. Nosser around the concept of fissured work. That is a term coined by Professor David Weil at Brandeis University. And this is a term that basically means that the business or entity that employs a worker isn't the one who controls how the work is performed. And the reason for that is because of commercial pressure imposed through a contracted or networked business structure that basically means that the employer has limited control over the work and the conditions as well. So, an example might be a retailer who engages a contractor who then employs a worker, but the terms of the commercial contract imposed by the retailer don't allow decent work principles to be upheld or legally compliant conditions to be adhered to. And this, I think, is a very relevant point because in recent decades we have seen fissured work arrangements proliferate across labour markets in Australia and many other countries as well. And that's definitely the case in textile clothing and footwear, but it's also the case in construction, in business services like cleaning and security, like in the supply chains that support retail at the retail sector, food, fruit and vegetables, and the like. So the model that the code incorporates reflects international best practice. It does so for two reasons: because it provides accountability for what David Weil calls the lead firm, the firm that at the top of the supply chain, like the retailer, who through their commercial power basically controls the work that's being performed by everyone within the supply chain, and also because of the monitoring and enforcement that it provides to empowered independent agents like trade unions or like government agencies. So it's a model that I think is very well designed to support the work of this committee around modern slavery, given that modern slavery, and Associate Professor Boersma can talk to this more than I can, embodies those characteristics of fissured work. It's one of the central features that lies at the heart of modern slavery. So I might leave my answer to that question there and pass to Associate Professor Boersma for further comment.
Yeah. Thanks, Chris. No, that's absolutely true, and I think and thank you for I suppose scheduling Mr. Nossar before we appeared, because he obviously gave such an excellent I suppose outline of how the scheme operates. But as my colleague Chris mentioned, a lot of the characteristics that make people vulnerable to modern slavery we see in the TCF industry, but as he rightfully points out, we see that particularly happen in these fissured workplaces where I suppose people quite often fall through the cracks due to I suppose the opacity of those supply chains. And this brings me to a point that I had wanted to make before as well, when the question of the chair was directed at me as well. So currently there are only a certain number of entities based on the annual review that they make that have to disclose their sort of modern slavery mitigation risk measures. And while federally at least they're considering to lowering that threshold, a lot of the entities that would have to provide transparency in the TCF industry would not make that threshold, and that would mean that we have a large blind spot effectively if we weren't to utilize this particular scheme. And that obviously also applies to the potential broadening of the scheme, which my colleague Chris referred to, and which Igor and Luigi also referred to. A lot of those entities, the smaller ones, would not be captured by the legislation, and I do think, again, coming back to, I suppose, the blind spots and the idea that obviously modern slavery oftentimes occurs in those places which are more opaque, where people are more likely to fall through the cracks, and those smaller entities would ultimately also be captured by these types of schemes and initiatives, which would shed light indeed on those sectors where people are most vulnerable.
Mr. Dr. Kane.
I've got a follow-up question. Often when you talk about modern slavery in an Australian context, and even when we're talking about it here, and we're talking about pressures in supply chains and that kind of thing, but non-compliance with labour law, though, isn't the same as modern slavery, is it? What's the connection there?
Yeah, no, I'm happy you raised that. Modern slavery is a bit of an unfortunate term in many ways, because it always conjures up connotations with what might be coined traditional slavery. And modern slavery, basically, one of the key differences is that traditional slavery was more about legal ownership, where this is about illegal control. So as a result, modern slavery should be seen as occurring on a spectrum of exploitation, where people might initially experience lesser forms of labor abuses or simple forms of labor standards non-compliance, where that's not meeting their or not being given their legal entitlements. But people can move along that spectrum, so it's not a once and for all set of circumstances that you are exposed to. Indeed, times change, situations change, so people might move along that spectrum. And so we shouldn't see modern slavery and decent work as binary categories. There's a large area in between with large amounts of different types of non-compliance and exploitation that can occur. So I suppose coming at it from a proactive enforcement perspective as well. So what this scheme does, obviously, it would potentially nip worse types of exploitation in the bud. So if you are able to make sure that people do meet their legal entitlements or get paid their legal entitlements, and Mr. Nossar referred to this as well in terms of the I suppose putting a bottom in the market by having a scheme in place such as this, but also he referred to the Cleaning Accountability Framework, which has effectively also put a bottom in the market. You level the playing field and you stop that, I suppose, race to the bottom where you have these unethical practices just because profit margins have become so thin that a lot of, I suppose, suppliers and businesses almost have no choice but to, I suppose, look up the boundaries of what would be legally permissible and not. And therefore, you could potentially deal with these issues before they escalate into worse types of exploitation. So, yeah.
Okay, so if I'm looking at your your submission, part of it was transparency. You spoke about transparency. So part of the benefit of something like this scheme is improving transparency as part of it. But the other part is hopefully not finding modern slavery-like characteristics, because the scheme, if it's operationalised, actually prevents the worst effects.
That's correct. Yes,
okay.
that was what I was getting to.
Thank you. Associate Professor Wright, you mentioned that a code like this, and I know from your scholarship about supply chain regulation around the world, is best practice. I wonder if you could sort of contextualise that a bit, and is there anything else that we could look at for other thoughts or inspiration, or maybe expand a bit upon the best practice?
Yeah, sure. So there's been a lot of scholarship that's been done on this issue, and those two principles around the accountability measures for lead firms and having empowered independent agents to monitor and enforce. Those are features that are not common to many of the forms of voluntary codes that you referenced in your questions to the previous witnesses. So, we've seen in the past 10 years or so, including in this industry, major multinational retailers adopt voluntary codes of practice that are aimed at demonstrating that they're being proactive around ensuring that their supply chains are free of modern slavery and practices and associated practices related to non-compliance with legal standards. So many of those measures don't provide firm accountability mechanisms for the lead firm, the retailer involved, because they're voluntary. There's no one really to hold them to account. That's where the state has a very important role, I think, in providing that accountability. And they often don't empower independent agents like trade unions, for example, to be involved. There are other schemes in other parts of the world that do provide measures akin to this. So in the United Kingdom, there's an agreement called the National Agreement for the Engineering and Construction Industry, and this provides those two measures, lead firm accountability and empowering unions as independent agents to enforce the agreement. This is a scheme that is supported by unions and also employers because of the benefits that are produced by this arrangement in terms of supporting decent work, avoiding modern slavery-like practices, especially at the bottom of the contracting chain, and also productivity benefits, reduced industrial disputation, and greater certainty for businesses involved. So, there are significant benefits from these type of arrangements. They also help to reduce commercial risks as well for lead firms. So, just to take one example from this industry, 11 years ago there was a disastrous factory collapse in Bangladesh, the Rana Plaza factory collapse. Many of the retailers and clothing brands that were sourcing directly or indirectly from contractors in that building had no measure to provide oversight or to ensure that the health and safety practices that had contributed to that disaster were avoided. Consequently, many of those businesses were either under pressure from unions and community organisations, or from governments, or from investors, were compelled to up their game. Were a measure like this, had it extended beyond the jurisdictional boundaries of Australia, I know that it does beyond the boundaries of New South Wales within Australia, then those sort of risks would have been minimised for the Australian businesses that were associated. So in terms of potentially extending the scheme, this sort of scheme, the measures involved, could significantly help to reduce commercial risks for businesses within the supply chain.
That is really interesting, thank you, and thank you for both of those examples. It does. I do want to ask a bit about this co-enforcement. Both the ethical clothing scheme and the schemes you spoke about, and we heard evidence from Mr. Nosser, speak about the importance of having businesses involved. And I think there may be a danger if people aren't aware of that kind of involvement, of reading the code and of thinking this is some kind of union scheme that sends a union in to do something, I don't know what, but to do something. But that's not really what it's about, is it? Could either of you explain a bit more about the importance of that multi-stakeholder approach, either using this or other examples?
Oh, sure, I can go first.
I must say just one point and then pass to my colleague. So, I mean, what constitutes effective regulation of work? In Australia, we have a tradition of the state having a strong role, and that's been effective for the most part from my research. But one of the things that comes out of the international evidence about effective regulation is the importance of both worker representatives and business representatives being involved, because they are the actors with the greatest stake in ensuring compliance and effective regulation that balances the needs of workers for fairness and business for certainty. A state-led model of regulation has benefits, but the most effective models of regulation supported by the state are those that proactively involve both business and workers and their representatives in this process. And I believe that this scheme does that through the measures that it contains regarding transparency and monitoring and accountability, and the roles that retailers and trade unions play in those processes.
Yeah, absolutely. I can second that. So what we've seen initially, when I spoke before about, I suppose, the more opaque parts of supply chains, and we've seen that both globally as well as sort of within Australia's borders, is that you have so-called governance gaps, like little parts of supply chains that I suppose become so obscure that we're not really sure what's going on, and that has happened, like I said, both globally as well as domestically. And the initial response to that was for companies to come up with their own codes, for business to, I suppose, regulate themselves to try and address that, and that has not been highly successful. And I suppose from the mid-2000s and later onwards, there has been more of a move towards multi-stakeholder initiatives and strategic co-regulation, where there was recognition that if you put all the stakeholders together and to try and address the issue, then you get various very valuable insights into what the problem is, and you can together put the finger on the sore spot. But also in the context of, I suppose, contemporary labour standards enforcement, it's the idea that it's just a regulator that can do it all by itself, for example, is outdated. So you do need the union involved in that capacity. You do need the industry involved in that capacity. You do need big bodies, the companies themselves, and most importantly, the workers involved in those initiatives to again put the finger on the sore spot and to, I suppose, effectively come together and try and address this issue. And we've referred to the Cleaning Accountability Framework before, which is a prime example of an industry which has been plagued for many decades by labour standards non-compliance due to cutthroat competition. The union itself couldn't solve it. The Fair Work Ombudsman itself couldn't solve it due to various reasons. The industry itself surely couldn't solve it as well. And they have ultimately all come to realize that when they join efforts in order to address this problem, they have a much better chance of addressing this issue. So yeah, sort of the multi-stakeholder route and bringing stakeholders together is definitely the way forward. And I think the scheme offers avenues to do the same.
Of course, the point that was made by Mr. Nosser was the difference between the scheme and, for example, CAF, is that you do still have the involvement of the state, which is what you were talking about in terms of, so it still provides that greater impetus for non-ethical players to be involved. I wonder if I could just ask, both of you mentioned, traditional labour law, and that it no longer, because one question would be, well, traditional labour law has done this work in the past. We've had it work. What is it about the characteristics of modern work that mean that the traditional kind of labour laws and arbitration systems and things that we've had in the past doesn't work?
I might have the first to go at that. Well, I think because labour law, employment law is built around the assumption of a direct employment relationship between an employer and employee, and whereby the employer is effectively is not only just managing that worker but has control over that employee's conditions. This industry is characterised by other actors, third parties, effective business controllers like retailers, that whose commercial activities invariably influence the employment relationship or the work relationship between a contractor and a business who engages their services. So there's, I know there's been discussion, in the previous session about, whether changes to the law, state and federal, since the establishment of the code in 2005 render it redundant. And my answer to that would be no, absolutely not. That the code is a way of making awards, for example, as one form of employment law, work more effectively, because awards are a necessary but an insufficient measure of regulation, because all they do essentially is provide a minimum standard that the employer of the employee is obliged to uphold. But when the employer has limited capacity to uphold their responsibilities because of the commercial pressures they're facing through their commercial contract with the retailer or with the contractor who's engaging them, then that they have limited control. So having an additional measure in the form of a code that brings the lead firm, the retailer, explicitly into the arrangement, provides accountability to them to monitor and enforce and work with empowered independent agents to do that. That is necessary. In many ways, Australia's systems of employment law, state and federal, it reflect that kind of, they're rather old-fashioned in that they are based around a relationship, the assumption of a relationship between an employer and an employee without incorporating explicitly other third parties. We need measures like the code to ensure that labour law reflects the realities of work and business in 2024.
Okay, Dr. Wright, I'm going to now move to Ms. Leon.
Thank you, and thank you both for your responses so far in your submission. I wanted to just get to something because I want to give you the chance to talk a little bit more about it, is the discussion of establishing a supply chain database. And I guess I just wonder in the discussions that we've had so far around the sort of lack of resourcing or engagement with this at a departmental level within the public service and within government. I wonder, how do you see that sort of working? Where would you see it being resourced, and who would ultimately be responsible for sort of maintaining it and that kind of thing? Because I appreciate the recommendation around it, but do you have thoughts, given the risks around the scheme itself and the code being sidelined, do you see a place of where that would sit such that it would actually be delivering what you're hoping it would?
I think that would naturally sit with New South Wales Industrial Relations, to be frank. I think that one of their roles potentially could be to, I suppose, establish standard operating procedure around that. So from my experience with, again, coming back to Cleaning Accountability Framework, but my experience is that all the stakeholders that are meant to provide information, but also the stakeholders that are meant to digest that information, benefit greatly from really straightforward guidelines and streamlined procedures as to how to submit that type of interpretation. So if it's clear for retailers, for example, through the establishment of templates, through a simple online portal or a simple email address where you would send that to, it would make that information provision a lot easier. Also, the regulator as an objective body would be a natural place to submit that to, potentially also due to possibly commercially sensitive information or other information. But also, I suppose, from an enforcement perspective, then we're very well placed to look at that data, look at those submissions, and through the existing data points, but potentially through extension of the scheme and the inclusion of additional data points, it would for them be easier to establish where there might be little red flags as to potential labour standards non-compliance with, for example, the submissions of information that submit profit margins that are so thin that potentially somewhere corners are being cut. And that could lead them to strategically direct their resources to follow up with an audit or an additional request for information, etc. So ultimately, New South Wales Industrial Relations would be a natural place for that to sit, in my opinion.
Yeah, great. Thank you. And I guess to a broader issue around and the pointing to the Industrial Relations Department in relation to that, and recognising that currently the Anti-Slavery Commissioner and responsibility for the Modern Slavery Act actually sits with Department of Communities and Justice. Given the submissions we've received from a number of people to see the idea, to use Mr. Noss's words, to resuscitate this scheme and the code. And given that you're aware that we're reviewing currently the Modern Slavery Act, I wonder, do you have thoughts about whether there is a potential to, in one hand, strengthen the enforceability and the direct compliance elements of the Modern Slavery Act by learning from this code, and potential for an integration between those elements? Not sort of just, because I think historically we've seen that they're sitting very much in different departments, but we hear all of the evidence and we all know that there is a direct link between dodgy labour practices and risks of modern slavery, and yet they're seen as such separate entities. I wonder if you have thoughts about the potential for the multi-stakeholder model being applied to the Modern Slavery Act, but also if there's an opportunity for us as a committee to look at the review of the Modern Slavery Act in a desire to strengthen it with the potential sort of regulation model that involves other stakeholders. So.
I can briefly start. Absolutely. And I think from what I've learned, Commissioner Cockayne has been very busy meeting all different departments and other people that have been working in any area related to labour standards compliance and whatnot. So he obviously, his office has made a submission, co-authored also by Ms. Justine Conybeer as well, I suppose articulating what a role is that his office could play in the enforcement here. And indeed, my colleague Chris and I, as part of the recommendation 3, do think that there is scope to articulate that collaboration between those departments more succinctly. And obviously, the New South Wales Anti-Slavery Commissioner Office has only fairly recently been established, so it's still, I suppose, in its early days and finding its feet and finding a form in which it best operates. But articulating, I suppose, the role that they could play and finding effective ways of resource sharing, finding effective ways of, I suppose, working together to come to more, I suppose, effective enforcement would be very valuable. And indeed, the Commissioner has articulated in other areas such as renewable energy, I suppose, particular guidelines and codes recently as well, which is obviously a very important area. But this similarly could be an area, and I think there is a role potentially for a broader working group, which includes people from New South Wales Industrial Relations, but also from Commissioner Cockayne's office, to come together and sit and see which elements from this particular scheme, the core elements, can be taken and potentially transposed onto other high-risk industries. So I just definitely see fertile scope for collaboration there. Yeah.
Great. Thank you. Did you want to come?
Yeah, thanks.
So I'm not sure if you've been downgraded with your doctors to professors, but I'm
we have
either way. Chris, please.
Thanks, Mr. Long. Yeah, look, so I think that it is a model that the committee should consider for strengthening modern slavery regulations, both in terms of the accountability mechanisms and transparency mechanisms, but also in terms of the regarding the threshold. This is an industry where many of the businesses, as we say in our submission, are under the $150 million threshold. The code provides effective mechanisms to cover those businesses, and so there are, I think, those 3 elements of the scheme around accountability, transparency, and coverage that that the committee should consider when reviewing the Modern Slavery Act.
Great. Thank you so much for that.
Mr. Borzak
No, I'm fine, thanks.
and Mrs. Ayad.
I'm okay, thank you.
Okay. Any more questions, Dr. Kane? Ms. Leong?
I think I'm okay.
Yeah, if we've got time, then I will just ask one more, and that was your thoughts around, because obviously there's the good sides of multi-stakeholder involvement, and the negative sides being that no one feels like they own it and have accountability and responsibility for ensuring that it happens. I know that there's mention within the Act, the idea of a council existing, which, as far as I can tell, doesn't exist.
It used to.
It used to exist, but doesn't anymore, and it's unclear who's responsible for ensuring that it does exist. I just wonder if you have thoughts about how we ensure that there is some ownership or accountability or responsibility at a ministerial level and a departmental level for ensuring that this scheme, as it sits, is actually adhered to and applied.
Yeah, that's a very good point. For all their, I suppose, benefits and the virtues that have been sung about multi-stakeholder initiatives, it is true that progress can be glacial, and some stakeholders might be dragging their feet, and oftentimes just joining is seen as an act of we're trying to do the good thing, but not really actually effectively and working towards solutions. So. Reiterating my previous point, I think a natural place where this scheme could sit would be, I think, New South Wales Industrial Relations. That would be, I suppose, a natural place where it could sit. And I think if they would be spearheading initiatives, that could be very helpful. But also from the idea of, okay, well, participation in this scheme is good and, potentially could lead to stopping worse types of abuses and labour standards non-compliance occurring. So I suppose for them it is a bit of a carrot as well. Like for retailers, you can join and be proactive and try and sort this out, rather than later on being confronted with a particular abuse and the potentially New South Wales Industrial Relations striking a different tone and using more of a stick than the initial carrot.
Sorry.
Sorry, I have just some additional thoughts.
Yeah,
in
please,
answer to your question.
please.
Sorry if that's okay. Yeah, so look, I think that a council model is a very good one, and it works in some of the examples I mentioned, such as the National Agreement for the Engineering Construction Industry in the United Kingdom. They have a National Joint Council for the Engineering Construction Industry, without which that agreement would not have achieved the success that it has throughout its 43-year existence. The council consists of equal representatives from employee representatives, the unions, and the employer associations, and an independent chair that is jointly agreed by both parties. So it's a model that's worked previously well in Australia. Another ingredient is ensuring that workers and indeed businesses are represented effectively through that structure. So I know there have been recent changes to Commonwealth law around trade union access to workplaces. We're yet to see what the impacts of those are, but having a well-represented workforce and business community is widely identified as effective, as necessary for effective joint regulation to occur. That's what we see in the Nordic countries, in Germany, in other parts of the world. And so ensuring that those measures are in place in this industry and in other industries where this sort of model might be expanded to, I think is absolutely essential for its future success.
But it's fair to say, I think, pick up the point from Ms. Leong, that having a code that's notionally meant to have a base and a regulatory force based on the state, if it's not housed somewhere within state apparatus, or if it's not auspiced or driven, then it's going to be difficult for that to have, beyond what ECA and the union have been trying to do, it's not particularly useful, is it?
No. Yeah. I think state involvement or state support is absolutely vital.
Yeah, and it seems unclear. It seems a bizarre situation that we have a requirement for a council. No one's removed that requirement, but it seems there's no details as to who's responsible for that council.
We might. I did have a discussion with Mr. Nosser prior to the hearing and reflected on the
Yeah,
fate
okay.
of the
Yeah,
council,
great.
and I think it actually may have had a specific time frame. So I think it may be worth our going back and finding out precisely what happened to that and why that was the situation.
Totally.
It established the Home Workers Code of Conduct,
Yeah.
which then became ECA.
Yeah.
And yes,
Yeah.
so I think it's worth us perhaps seeking some further information to clarify what happened in that
Yeah.
instance. But
Yeah.
clearly, you've reiterated, Dr. Wright, the value of having that council and that structure in place.
And it doesn't mitigate, it doesn't take away from what we're saying about regardless of the council, if there's a code and it's state endorsed or state derived, then it needs to have a home.
Yes.
Yeah, totally. Which I
Yes.
think is the,
Yes.
Key
the
thing.
bigger question here, right? And who's responsible for it being
Which part of the
resuscitated?
government?
Yeah.
All right.
I would agree with those comments. For the
Love
report.
it.
Great, thank
Great, thank you.
So can I just thank you for your evidence? The Secretariat will contact you if we have any, in relation to questions on those, and if we have any further information or requests. Thank you very much. At this point, I might ask you to withdraw, and we'll take a short break. We'll take a short break in the hearing and reconvene at 11:15.
Thank you.
Thank you. Thanks
Thank
very
you,
much.
Chair.